it's almost like a significant harassment and abuse of defendants, and frankly, vexatious litigants is about abuse of the entire justice system.
So, welcome back, everybody, after a brief hiatus to Beneath the Law, to our next episode. Stephen Thiele, how are you, sir?
I'm good. You know what? I think we needed a break. Life was getting busy.
That's one of the things about law.
Oh, God. You know what? It's been a foggy time since November, that's for sure. Lots of other issues going on, and the skies have cleared. What can I tell you?
Yeah, it was a crazy time. One of the things about practicing law is that it does come in waves. Sometimes they're little, lapping waves on the beach, and other times it's Phuket. It's like a tsunami. So we did endure that. We've come out on the other side, better, stronger, faster, and ready to rock on some great legal issues.
Yeah, and let's get back into these, because it's just incredible the number of things that we're seeing, and we're going to talk, I guess, a little bit about vexatious litigants, Gavin.
Yes, our favorite friends, a lawyer's best friend, a defense lawyer's best friend, um, a vexatious litigant. Listeners will wonder, well, aren't all litigants vexatious? And the answer is yes. But as with all things in law, there are questions of degrees of vexatiousness. So let's think about what the term vexatious means. I love it. It's one of my favorite words. It means someone who seeks to vex. And it reminds me of one of my favorite movies, Gladiator, when can't remember my favorite movie. I can't remember his name. I can picture him, Johnny Cash. He said, "I am vexed because the little bee has been buzzing around." But to be vexed, it's very Shakespearean. But it means to be, hurt. It's someone who is seek to vex someone else, to put them in a bad spot. And a vexatious litigant is one who uses litigation to vex their opponents. And that is not a good strategy in terms of courts of justice.
Well, it's almost like a significant harassment and abuse of defendants, and frankly, vexatious litigants is about abuse of the entire justice system.
Exactly. And one of the things that we've seen a great deal of and heard a lot about in recent times is lawfare. And in the U.S., there's been the discussion of the use of prosecutorial powers for political ends. I mean, certainly Donald Trump was fond of casting himself as the victim of lawfare on any number of occasions, and whether that was true or not. And lawfare is nothing new in terms of civil litigation, certainly, and vexing one's opponent with a series of frivolous and foolish lawsuits is a tried and true tactic, and something that in Ontario, anyways, the rules, in fact, the Courts of Justice Act, prevents and allows the court to deal with people who are vexatious litigants, in the sense that they pester their opponent with a series of frivolous and vexatious lawsuits.
Yeah, and so let's, I guess, maybe get into it in terms of the background of how we've got this podcast to talk about vexatious litigants. There are a number of cases that have come up in court, and I think you once were involved with one, or one of the earliest ones, where you had a litigant declared vexatious. But what we have had recently here, um, in March of 2025, was a case that involved a plaintiff. I'm going to try and stay away from the gender of the plaintiff. It might come out, but a plaintiff who started 13 legal actions, 10 of which were commenced after being involved in some acrimonious family law proceedings, sued the police multiple times, sued their lawyer 5 times, had claims dismissed, and notwithstanding the dismissal of the claims, restarted the claims, made all kinds of accusations that judges, police, lawyers were involved in a crime syndicate, posted on social media about judges, being just terrible judges, making all kinds of accusations that they were rude, etc., etc. And lo and behold, the police, who had been sued twice already by the plaintiff, who threatened to sue them a third time, brought an application to have this plaintiff declared a vexatious litigant.
Yeah, let's talk about that application. I mean, uh, before we leave it, we will come back to some pretty interesting war stories of the crazy plaintiffs. I've had a few of them over the years. Some of them are pretty funny. But a vexatious litigant application is brought basically for a declaration that someone is abusing the court process for improper purposes, vexing their opponents. And basically, it's a gatekeeper type function. So once someone is declared a vexatious litigant, and it's not easy to do, I guess it shouldn't be easy to do, although sometimes I think it should be a little easier than than others. But in any event, it's basically a gatekeeper function in the sense that it doesn't stop somebody from bringing meritorious lawsuits. It just means that once they're declared a vexatious litigant, they can't run off to the courthouse and issue claims without permission or leave from a judge. In other words, there's got to be a vetting of their use and access to the court system to sue people. So, in other words, if they had an actual legitimate claim that on its face had some prospect of success or reality, they could go ahead. They get leave and off they go.
Well, yeah, and Gavin, just to interject there, I think that's an important point. That the declaration that somebody is vexatious does not necessarily deny them access to justice. And, we live in a Western democracy. The justice system is obviously a cornerstone within, part of the foundation of democracy. Courts, protect rights, they promote social stability, they enhance public confidence, in government, because they ensure that governments don't abuse their power. So courts are meant to be available to everybody. But as you say, the vexatious litigant is the gatekeeper function that says, well, hang on a second. Some of the people who use the litigation system use it improperly, and therefore, in order for you to get access to justice, a judge needs to first see that you actually are bringing a legitimate and not abusive.
Yeah, I mean, I say this all the time. People say, "Oh, can I get sued for what by so and so?" And the short answer is, yeah. I mean, you can get sued for anything. My common response is, look, if somebody wants to sue you and they've got, I think it's whatever the fee is this time, it was $350 or whatever it is to go down to the courthouse, and they want to sue you because it's raining today, they can sue you. They go down to the court. If the statement of claims looks like it's in the right form, and they pay their money, and the court gives it a stamp, and you're sued. So the fact that there's no merit in it doesn't mean you can't be sued. But with a vexatious litigant order or declaration by the court, it does. You cannot be sued. Now, I often wonder, and we can talk about this later, I wonder how it's possibly enforced. I don't know that there's a registry of vexatious litigants that if somebody's went to issue a claim could be run through a database and they would say, you need leave. And I often wonder if you were truly vexatious, I'm sure you could find a way around it. And we could talk about that too, because I had, as you mentioned, personal experience in this, which was pretty humorous in hindsight. But the short answer is no, you can't just sue anybody. you can't sue somebody because you don't like the weather today. You need leave of the court to do that. And if, as I said, there was merit in the lawsuit, i.e., something beyond the meteorological cause of action, you probably would get leave. I mean, I think the court would be pretty lenient in terms of a case, and it would look at it just like they would on any other motion to strike a claim to see if, theoretically, if you could prove the facts that you allege, would a cause of action stand? And if the answer to that question was yes, I expect you'd be allowed to proceed. Although I don't know, I have not read, and you may have read one, of a case where a vexatious litigant was actually permitted to proceed with a lawsuit subsequent to the declaration, and what the test for leave would be. I'm not aware of any authority on that. I guess vexatious litigants, leopards don't change their spots, and they don't come up with actually meritorious claims.
Yeah, I've never seen a case like that. And one thing that I do want to mention, just to back up a little bit on your comment about, the issuing of the lawsuit because it's raining outside, and that somehow I'm responsible for the rain, or
What are
somebody
you
else
saying?
is
You're not?
responsible for that.
Come on, we all know. I saw you in there doing your dance, making it rain.
Yeah, well, exactly. It depends how much thunder and lightning I bring
Okay,
to the
Zeus.
table on any given day. Uh, um, vexatious proceeding is a little bit different than a vexatious litigant, right? So somebody who brings a vexatious proceeding, one that really has no reasonable chance of success, that's knocked out under a different provision of Rules of Court, or Courts of Justice Act. But a vexatious litigant declaration is personal to that individual or that person. That's certainly much more significant kind of order that's made. I take your point. I'm not aware of a registry. And that's a interesting point, and maybe something that government needs to create, so that courts all over the place do know that somebody is a vexatious litigant.
Yeah, I'll tell you my story while we parenthetically pause there. Um, so I had uh, a litigant in London, Ontario, who liked to sue everybody. It was quite remarkable. He had a great means of moving his briefs around. He was obviously a self-represented fellow, although very experienced given the number of lawsuits he'd commenced. But he didn't have a briefcase. He used to roll his lawsuits around literally in a large baby stroller, which full of files that he would, because I guess they were his babies. But anyways, he had a baby stroller that he would, a large pram, one of the old style prams, full of files. Anyways, after many, many years of litigating a case, we went to trial. Actually, it was one of the most hilarious trials. Up maybe another episode is the infamous Aristocrat trial. But in any event, he we brought an application because once he lost, of course, what he did was he never lost. That was just a mulligan. It was just an excuse to bring another lawsuit. So I think after round 3 of getting these lawsuits struck out, we brought an application to have him declared a vexatious litigant. And I'll never forget the day that we got the order in the court. It was back in the old days when they actually did paper orders and the judge would sign it. And we brought it down to get the order entered in the registry in the clerk's office in London. And I remember walking through the door and handing it to the clerk, and they literally started cheering in the court office because apparently this gentleman literally came there every day to issue a new claim against somebody, and he was quite belligerent with the staff. So they took the order that had been signed by the judge. They photocopied it. They pasted it at every single kiosk in the clerk's office so that everyone would know not to take any more claims from this gentleman. So they had their own registry system. But I often thought that, what was to stop them from, I guess, well, maybe the pram wouldn't go that far, but you could have rolled down the road to Guelph or Halton or somewhere else or some other court office in some other county and issued a claim there. So I do think that if you're going to do this seriously, that there should be certainly a provincial registry of vexatious litigants, so that someone just doesn't find another locale to purvey their wares of lawsuits.
Yeah, certainly. If somebody's issuing a claim against the same defendant, it would be pretty easy because all you would do is file the order with the court in the different courthouse. But if you're a completely new defendant and have no idea that this person's been declared a vexatious litigant, how would you know?
There's no way to know.
Right?
Yeah, there's no way to know. So it is a good rule. I think it's an important rule. I mean, access to the civil justice system. You're right. It is a bit of a pillar of Western democracy. It is important that people have a means by which to have a resolution of their private disputes, because obviously, if people can't resort to civilized means of dispute resolution, they may resort to other less civilized means of dispute resolution, which is, I think, one of the primary functions of the justice system. And access to justice is extraordinarily important. I also think that sometimes novel claims are not to be discouraged, because novel claims are how the law advances. I mean, I think back to, who would have ever thought that suing a ginger beer manufacturer because there was a snail in my drink would lead to the evolution of tort law and the duty of care all throughout history. It certainly would have been a novel claim at the time. So every branch of the law that develops, certainly in the common law, starts off as a novel claim, and novel claims should not be discouraged. But people who use the legal system as a weapon to terrorize people that they hate, and you mentioned in the Ottawa case, and I was chuckling to myself when you said it came out of family law proceedings, as many, many, many vexatious litigants do. Unfortunately, family law proceedings seem to be a breeding ground for people who have issues that they seek to resolve in the court system, and then they roll those issues that they had with their spouse forward into claims against lawyers, as you mentioned, claims against judges, claims against everyone who has, they think, led to their unhappy state of affairs.
Yeah, and one of the things too, in some respects for me, is that the vexatious litigant declaration is almost a means of protection for the plaintiff who actually starts all of these lawsuits. In this case with the Ottawa Police Services Board, the plaintiff had some, bipolar mental health issues. And so the declaration that this person is now a vexatious litigant, hopefully, is a signal for that person to get some help. Now, our court systems aren't designed to give anybody mental health services or put them in touch with mental health care providers. But I think for this individual, that is important, and hopefully the declaration of being a vexatious litigant will help this person seek proper treatment.
Yeah. Listen, I think that one of the things we need to talk about is kind of laughing about the gentleman that I dealt with, and the glee of the court staff that they could finally stop issuing claims. But there's a real other side to this, and there's two parts to it that I think are quite important, and it's the real harm that vexatious litigants cause to others. Firstly, let's deal with it on a micro level. I mean, being harassed with lawsuit after lawsuit after lawsuit by someone who is obsessed with, revenge or what have you, has a real cost. I mean, this may be something that this person wants to spend their nights, on their word processor dreaming up ridiculous claims and issuing them. But you have to answer those claims. And I know, there's a real cost to that. I've dealt with several instances where it was lawyers who would be sued. And there's a real cost there. There's a real cost to the lawyer who has to take the time to deal with all of this, read the thing, report it to their insurer. There's a real cost to the insurer. This is real money. They got to retain counsel. I mean, an idiotic claim takes time and money to respond to just as much as a meritorious claim. And the other macro issue that I raised, and you raised this too, is that our justice system is strained past the breaking point. I mean, it is at a point where the courts just simply cannot deal with the inflow of lawsuits and process that they're inundated with. And the problem for every, ridiculous, vexatious claim that comes in the door, that takes away from the court's ability to deal with real issues and real problems where the justice system can have a meaningful impact. And that's, if you want to know why it takes you a year to get a trial date, well, look no further than the inflow of vexatious claims from vexatious litigants that are taking away the resources to deal with meritorious claims.
Right, and look, we see that more and more, and you and I deal a lot with the law of defamation, and the entire purpose of the anti-SLAPP provision in Ontario and in British Columbia is to get rid of those cases that are vexatious in a way because they're trying to suppress freedom of expression. And we see a lot of those cases, and they clog up the court system as well. And there's a gatekeeper process to get rid of them at an early stage. So, vexatious litigant declaration, as you mentioned earlier, is a gatekeeper function to make sure that the court is free of unreasonable claims that are plugging up our justice system and taking resources away from legitimate claims that are not now being dealt with in a timely fashion.
Yeah, I think one of the rules that I think is quite helpful here in Ontario that we finally brought in, and it's about time. And the gatekeeper function, I think, is important. I think the courts are a system that is rife for abuse. I mean, it really is in terrorem, frankly. If somebody's suing you all the time and you've got to keep paying legal bills to respond to it, that's a real problem. So there is Rule 2.1 under our rules where if a claim comes in which is clearly nonsense, you can write to the court and say, just read this. I mean, this is nonsense. Please don't make me respond to it. And the court will read it. And if it is truly nonsense in the sense that it clearly has no chance of success on its face, the court can issue an order to dismiss that claim. The vexatious litigant branding, if you will, goes further than that. What it does is it declares an individual to have a proclivity for generating vexatious claims and almost creates a presumption that anything that comes from this litigant will be vexatious. It doesn't deal with reviewing cases on a case-by-case basis, which obviously is time-consuming and eats up the resources of the court, but actually reverses the onus and puts it on the vexatious litigant to demonstrate why their claim should go forward. I actually think it's the inverse of a 2.1. It's up to the plaintiff to go to the court and say, you should let me proceed with this lawsuit. And this may seem quite draconian on my part, but I wonder if, there might not be something that the rules should be looking at in all sorts of jurisdictions, not just in Ontario and not just in Canada, but almost a gatekeeper function in terms of claims everywhere, such that there should be some screening. It doesn't have to be very deep, that's for sure, but on a very, very superficial level, that before you can issue a claim, it has to be reviewed by some sort of a magistrate or a judge or a low-level person to see if it passes the lowest bar of merit.
I don't know. That is a very interesting question, Gavin. Would probably add a lot of red tape potentially to the administration of justice. I'm not sure.
Well, the question is, where do you get your red tape? You get it at the front end or the back end? Because you're getting it one way or the other.
Well, it's red tape all over the place. Look, this is a great discussion, obviously, on vexatious litigants. There are other rules, collateral attack rules. I think vexatious litigants declarations are an evolution of what already existed in the law in terms of knocking out actions for being collateral attack on previous decisions and etc. I think it's a great rule, and there are a lot of other ideas that you raise as well and that's why we're here. If nobody is above the law, we're all beneath it.